Audhu Bismillahirrahmanirrahim. Today my lecture the term of contract, general considerations. Would you like to my channel Legal Talk Network? Subscribe and press the button bell icon. Like it, share and comments. The content of contract. There is a three aspects of the contracts. Construction with the needs of considers. A. What are the terms? A contract is a bargains between the parties. The contents the contracts are therefore principles expressed in terms. This content of this contract, therefore what are the parties of the orally in a writing. Second, the strictly limited circumstances. The court are prepared to imply terms. Third, what is the status of these terms? Obviously, not all terms to equal, potent. If you are buy a car, suppose, and find there is you doesn't have to about either a radio, then is a seller, it is a breach is a term. It is not is a very important term, and you will be satisfied if the seller give you money which to buy radio. If you buy a car and find there is a no engine, then a fair more important terms in a breach, it may be term money will not be enough to way of the reported date in the contract eligible. Their more important terms of contract are called consideration. Less important terms called warranties. Where is the important of terms is not apparent until the have to be into broken and a term of called anominations. When do those and the terms of come into effect? Sometime a term operate, suspect, terminate the contract. The term is the called is a condition is procedure is a conditions subsequent express term. As we have already seen, the term of the contract. My word is not Donald Trump. My word is a contract of terms. Maybe only oral. Only is a writing, a party and a party in writing. Terms, holy, oral. This present is a pure questions of the fact, but did the parties actually say the terms. Wall is a writing, the contract which is holy writing is subject to the parallel evidence rule. The rule is the if there be contract which has been reduced into writing, verbal evidence is not allowed be given of what passed between the parties either before the writing instrument was a matter during time it was in the in the status of preparations. So as is had to subtract from into manner to very quality the writing correct contract, the parallel evidence rule applies only to the express terms of the contract. It doesn't apply in the completely. Validity of the contract, valid contract in the whether mistakes and misinterpretations, about in the absence of the considerations, the term of the penalty and the penalty in writing. Sometime start agreement maybe an oral example agreement to be by a a ticket, but it may be subject, as I said, written, standard terms. He was told by a attend, not we look, they care, so we gave, to the attend to be agreed to look the car when the bed moved. My loss or damage, however, cost, like, above the, you know, the court of appeal, able from the laws of the, languages that are not wise in the express, claim clause letter, and must be fail in the, there are repugnant to the express understanding. I will next lecture, inshallah, I will come to subscribe to my channel Legal Talk Network. Pakistan Zindabad.